Okay, so that concludes part one, which is which we talked about entity planning. Amber, do we have any questions?
There are no questions in the chat box, but I would like to mention that in the chat box, after the meeting, I put a link in there and you can go out and fill out an evaluation form. You have to fill out the form in order to receive a copy of the slides from today and links to the extension workbook. And Dr. Alex White actually sent me another workbook from Farm Credit, I believe it is, that will also help you in this planning process. So in order to get all of those links and the link to the recording of this workshop, you have to fill out the evaluation form. And it's just, I know it's kind of like a strange caveat, but it really does help us better serve you as Virginia Cooperative Extension. So if you guys could just take a minute and do that. Dr. White said, are there any taxable events triggered by assigning real estate to an LLC or taking property out of an LLC?
Well, that's a good question. So generally what I do when I transfer property into an LLC, it will be a gift. And since it's a gift, the only taxable event I'm thinking offhand that will occur will be if the gift exceeds the annual gifting amount of $15,000. And then we will file a gift tax return to IRS Form 709. So let's suppose parents want to gift, let's say two parents want to gift one child $30,000. And I guess is not exactly the question, but if they put that gift into the LLC and they gift it to the child, there's no taxable event on that other than the gift tax return. Now, if the gifting process results in something being liquidated, let's suppose you have an investment account in the process of investing, transferring that to the LLC results in the investment account being liquidated. I don't know why that would happen. It might. Then that might result in some capital gains tax. But that's not because of the LLC. It's because you have liquidated the asset. Yeah, I think offhand, those are the two tax ones. So what I do is when we transfer assets to an LLC, let me give you another example because this just happened recently where a husband owned a considerable amount of real estate and the wife didn't own much at all. Now we created a husband and wife LLC and we wanted to equalize it. So when we had the husband place his property into the LLC, just after that transfer, we gave the spouse 50% so that when the dust settled, both husband and wife had 50% interest in the LLC. We sort of equalized the estate, which, by the way, could be really important if we're trying to avoid things like probate. Any other chats?
Okay. All right, hold on. Okay. I don't think there is one.
Do you want to open up for verbal, or should we just let that go?
I think that since okay.
We are getting a few questions now.
Yeah, Mary Craig asked, what if I wanted to transfer my house with a mortgage to the LLC? Does that trigger a tax event, and can the mortgage stay in place as it is?
So first of all, we're going to need to have a discussion as to whether or not we want to transfer the house into the LLC. Okay, there may be some issues that whether or not we want to do that. But if we decide to do that, let me just give you an example. Recently, I had a couple with a fairly large number of pieces of property, 16 altogether to be exact. And one of them was the residence. And we decided to keep the residence in their personal name, actually in their living trust. And then the other 15 pieces of property were transferred to their limited liability, actually family limited liability company. Now, if there's a gift, if we do decide to transfer the property, the residence, into the limited liability company, that's a gift. Again, it does not trigger any kind of tax at all. As far as I think your question is, the question that has people concerned is that when you transfer real property to a trust and the real property has a mortgage, there's the possibility that the bank could call in the loan. It's called a due on sale or due on transfer clause. I will tell you, in 27 years involved with thousands, literally thousands of mortgage properties, never once have I had a bank call in that loan. Actually, let me tell you, there's been one or two cases where that has been a problem. And all we do is we either we find that out ahead of time and we don't transfer the residence until it's paid off, or we fill out necessary paperwork to make the bank happy. What I also need to add here is that you cannot take a mortgage property, put it in an LLC, and then default on the loan and wag your tail at the bank. That ain't working. Okay, so if you transfer mortgage property into an LLC, the bank has a right to come after that property, even if it has the protections of an LLC. In this case, there's an exception because the property was mortgaged before it was transferred to the LLC. Gee, I hope that answers that question. If not, you can hang out afterwards.
Right. Last call for questions, if anybody has any, before we're going to go on ahead and move on to part 2.
Yeah, please be chatting or thinking of questions you want to ask. I love getting questions. Makes me I try to look smart when I do that. Okay, so let's go into part 2. These are contractual agreements.
Jim, it looked like David Wise had a question.
Okay, David?
Oh, sorry, David. I didn't even see that. I don't even know how I missed that. I apologize. It says if a business is set up as an LLC, it is recommended that they include LLC as a part of the business name whenever they advertise or list the business name. I see it done both ways with businesses that I'm familiar with. Is it recommended that they include LLC?
You read that kind of quickly. Read that again.
Okay, sorry. If a business is set up as an LLC, is it recommended that they include the LLC as a part of their business name whenever they advertise or list the business name? He said he's seen it done both ways, that with businesses that he's familiar with. Is it required that you put LLC after the name when you advertise?
I know the answer. It's just not coming to me. Generally speaking, when you operate your state corporation commission approved business, that you would use the proper terminology. For example, if you're not an LLC, clearly you're not allowed to use the word LLC or corporation or INC or anything like that. When I have clients that come to me and they say, we want the LLC to be one name, but we want to be doing what's called a DBA, doing business as, under a different name, or they might have a marketing name that is different from their LLC. So the LLC might be the farming LLC, but they have honeybees, and that's their big thing. And they might call it the Smith Honeybee Farm. You can do it doing business as. You need to have that registered with the local county, and then that needs to be run past the State Corporation Commission to make sure you're doing business as isn't in conflict with somebody with an LLC that has the same name. So as long as you're doing business as, it's registered with the county, and you don't conflict with anybody that has already using that name in the state of Virginia, that's fine. I have a number of clients whose LLC has one name and they're doing business as on another name. And I've helped people get this approved by the county and make sure the State Corporation Commission does not want us object. What you want to do, let me say one more thing while I'm thinking about it, is you want to make sure that doing business as is clearly covered by the LLC. And so what you want to do is you want to have a meeting of the LLC. This is where someone like me can come in handy. We want to make sure the LLC has a meeting of the minutes and passes a resolution authorizing the LLC to operate as a doing business as. Otherwise, people may say, well, you were like a rogue activity, and I get to sue you personally as well as the business, and that would be a really bad result. So again, I hope David, that answered your question. Any other chats?
I don't see any more. So I guess we can just go on ahead and move to part 2.
Okay, shoot away. Like I say, I'd love to get questions. I think it kind of adds a little personal aspect to the presentation. Okay, so contractual agreements. We've got some types. Buy-sell agreements would be a contractual agreement. A lease agreements, conservation easements. And those pages are referencing the VC, Virginia Cooperative Extension workbook. So when you get that, you can ask for a copy of the slides, and you can see where these are covered by these various areas. Okay, something a little about buy-sell agreements. So the buy-sell agreement is critical in cases where you want to make sure that the business stays in place when certain triggering events occur, such as the death of an owner. So let's take a case where you have two brothers that are running a business, and at the death of the first brother, we want to make sure that the surviving brother gets the entire business. So that, because the default, if two brothers own a business, the default is the decedent brother's share goes down to his spouse and or children, and that might not be what is desired. So what we'll have is we'll have a buy-sell agreement that will simply say, look, at when brother A dies, the brother B gets the entire business. So we have that in writing, so nobody's unclear as to that happened. And then the second part of it is that the decedent brother's estate gets a payoff. And the buy-sell agreement will define what a payoff is involved. I'm involved right now in two very extensive buy-sell agreements, and it takes a while for all the parties to come together and decide what will happen if, in one case, we have three partners, and in another case, we have two families, and it's becoming critical in where we have two families. It's what we're going to do is we're going to have one family take control when this is actually the brother situation, where one of the brothers dies in one family, and then the family that is of the decedent brother gets a substantial payoff because it's a fairly wealthy business. Anyway, so this is when you do buy-sells. Again, I'll help you identify this when this comes up. Leasing and renting farmland. First of all, just a couple basic elements. The one thing I want to say is if you are leasing land to a third party, or you're leasing land from a third party, maybe this is the lawyer in me, but it really needs to be in writing. The few times that I have violated this myself, where in one of my offices, I don't have a written lease agreement. A lot of times I wish I did, because down the road, people have different interpretations about what was originally agreed in verbally. Identity of parties, we should make sure we know who the parties are. If there's an entity involved, we want to identify the entity and who represents the entity. Description of the property that's being leased. Do we have ingress and egress over the property, over non-lease property? Is there ability to make improvements upon the land? These are things that will be covered by your lease agreement. We want to make sure we have the term of the lease. Is this something that's indefinite? Is it something that's got to be renewed every year? If it is more than 5 years, it needs to be recorded to be legally enforceable. And what's the notice period if there's going to be a termination? The cooperative workbook has an excellent short-term lease checklist on page 76. So these are just some of the things that I think in my prior chart, where I had a farmer splitting land between his family limited liability company and the farming operations. The farming operations will enter into a lease with the family limited liability company so that the farming operations can operate on the family limited liability company property that is owned by that particular LLC. Conservation easements. I'll start out by saying conservation easements is a real specialty, and I work with people with conservation easements. I don't do them myself. Got a little fancy work going on here. Allows the landlord to continue to own the land while placing certain voluntary restrictions on the land, current and future use. So it's a voluntary written agreement between a landowner and a private nonprofit organization, would be such as a land trust. So, I mean, for those of you who have property that you think you might want to put into a conservation easement, there are people that specialize in this area. Okay, so that was a quick part 2. We're going to go into part 3, estate planning. So, Amber, any
I don't see any
chats on this?
in the chat.
We have a very contented group here today, which is fine. Okay, so let's jump right into part 3. This is estate planning. So let's regroup here. So we've talked about planning your business estate, and which is what we've just done. And we talked about contracts a bit. And so part 3 now is, how do we do estate planning? How do we manage this property while you are alive, when you are mentally disabled, when you pass on, and beyond? All right. And beyond, by the way, could in theory be indefinitely, forever. I have a case coming up in a month or so where I have a vineyard owner who is going to keep his vineyard in the family forever. It's called the Dynasty Trust. And in fact, we're going to have a little get together with all the children in about a month, and I'm going to present how the Dynasty Trust works when mom and dad pass on. Okay, part 3 then. Estate planning essentials. So let's put a definition on estate planning. This is a definition that comes out of the National Network of Estate Planning Attorneys, so I don't take full credit for this. I want to control my property while I'm alive, take care of myself and my loved ones if I become disabled, and give what I want to whom I want, the way I want, and when I want. And if I can, I want to save every last tax dollar, professional fee, and court costs possible. And that is precisely what we do when we do estate planning. This is not just a nice little sound bite. This is actually what we do. And this is why we think it's so important to do estate planning as part of what you do in your life.
Yeah, I might mention on that, Jim, just a quick comment. You know, this slide has 3 parts. As you see, there are 3 parts. And whenever I talk to clients about their estate plan, I always remind them that there are 2 parts to estate plan. The before death, who's going to be handling your money and managing your money and your income, your assets when you become disabled? Who will be taking care of your family and your businesses when you become disabled? So that's part 1, the before death planning. You need to have documents in place. Otherwise, the government will come in and handle that for you. Part 2 is after death planning. Who's going to be handling all these things after you die? So you can have documents in place that will put that control, that power within the hands of your family, your loved ones, and keep the courthouse and the government out of that. And that's what we're talking about here with regard to estate planning. We want to make sure both parts are covered. Jim?
Okay. Now, everyone listening in, all 40-some people listening in, and all the presenters, myself included, we have an estate plan. You have it whether or not you like it or not. It just depends upon how proactive you can be. You can be extremely proactive, or you can be not proactive at all. And we're going to talk about what the 4 types of estate plans, which one you fall into, and which one might be better for you. So First of all, there's the unwritten plan. This is the plan that has no documents in place. No, you don't have a will in place. You don't have a power of attorney. Or maybe you have such an old one, you no longer know where it is located anymore. By the way, a missing will is a revoked will. So if you have a will, but you did it 20 years ago and you don't know where it is and we can't find it, it's been revoked, whether or not you think it's been revoked or not. That would be an unwritten plan. You don't have anything in place. 2, you have a written traditional will plan. This would be, when people think of estate planning, I think they default to your common, ordinary, traditional will. So that would be number 2, a written will plan. A poor man's estate plan. This is an effort to avoid probate, but it's to the exclusion of proper estate planning. So you can avoid probate and get yourself in more trouble than if you didn't do anything at all. And that's the poor man's estate plan. And then the living trust plan. So those are the 4. Everybody listening in here, you have one of these, whether or not you like it or not. And the number 1 is the least proactive, which means that state and federal law dictates what happens. The living trust is the most proactive, which means there's a lot less, if any, government interference, be it at the local level, the state level, or the federal level.
One other thing, Jim, to mention too is that you might have a will, but it might not be valid. It might just be a copy, and you need to have an original. The courts will only take an original. So that will may not be valid, and then you're going to end up in the number 1 plan again, and that's where the government makes all the decisions for you.
Yeah, that reminds me, many years ago, I had someone die, and I was named the executor. So I took the will to the courthouse. I mean, I thought it was valid will, and it turned out that the person had an alias name, and on some parts of the will she used her alias name, and another part of the name she used her regular name. And I had to talk like a Dutch uncle to try to get that clerk to admit that will. She finally did. But there's an example of where something you think is fine turns out to have a problem that you didn't even see in the beginning. All right, so let's talk about the unwritten plan. I would have guessed in a group like this, there's going to be a couple of you that have this kind of plan, and I hope you are convinced that's not a good idea. Unwritten plan, state law determines all major decisions. Least favorable estate plan. There's a whole stable of lawyers out there that are waiting for you to die without anything in writing. Most common estate plan. And you're at the mercy of the court system while alive, what's called a conservatorship, and upon death, probate. In other words, the government gets 2 kicks at the cat for an unwritten plan. One is when you are alive but mentally disabled, and the second time is when you die through what's called probate. The first, when you're mentally disabled, it's called a conservatorship, and death is called probate. So there's two kicks at the cat, and by the time you're done going through this system, sometimes there's little or nothing left. All right, so that's really about it on intestate. This is, by the way, unwritten plans are called intestate. So if any of you, heaven forbid, should pass away today, and you do not have anything in writing, like such as a will, when we probate your estate, we'll call it an intestate estate, and that will let everybody know, the judge and the clerk of court and the commissioner of accounts and everybody else, that you died without a will. And they know then they got to start opening up the law books to decide things like who are going to be your executor, who are going to be your beneficiaries, how much people are going to get paid, how much they're going to pay the creditors, and that kind of thing.
Yeah, and the thing about this unwritten plan is the court decides who the executor is going to be, or the administrator, and so then the family could be shut out of that whole process. I mean, can you imagine that, where there's some stranger that's administering all of this, and you never know how long this is going to take and what it's going to cost. So,
yeah, that just reminds me, Sonia, I had a case many years ago where a lawyer, and lawyers are some of my most challenged clients, but this guy was married and had 2 or 3 kids, but he was living with another woman who was a immigrant. I don't think she was legal even, and he was living with her, and he dies in an auto accident up in Northern Virginia. And she skedaddles down to the court and gets herself appointed as the executor of the estate because, they were living together, and proceeded to prey on the estate to the disadvantage of the surviving wife and the two children. And so I represented the wife and the two children. It took us, I think it took us 3 years to get the, what I call the mistress off the estate plan. And we had to pay her a sizable sum of money at the end before her lawyer and her were satisfied with it. But a simple will stating that, hey, I named my wife and my spouse as my executor would have solved a huge amount of problems and a huge loss in the size of the estate that went to the surviving wife and the children.
Not to mention if you have little children involved, oh my gosh, you really need to have the will prepared properly, naming where you get to decide who your guardians are going to be. So it'd be terrible to have someone that you didn't like being the guardian of your children, of course.
So the next plan, so we talked about the intestate or the unwritten plan. This is I call the traditional will plan. So this is the plan where you have a basic will. I would guess in a group this size, several of you will have an existing will in place. It's probably been a few years since you looked at it. Hopefully you know where it is. Remember, a copy of the will doesn't count. You've got to have the actual original signed copy in order to have a valid will. Your traditional will plan called testate. So any of you that has a will today and you pass away today, we will caption your case testate. And that lets everybody know in the court system that you have a written will plan. And that written will plan is marvelous insofar as it overrides standard code provisions that will apply to you that you don't want to apply to you. So it names an executor. An executor is not the beneficiary. An executor is the person that manages the probate estate. So when you die and you have a will, some people think it keeps you out of probate. It does just the opposite. It takes you into probate, but it gives us much better guidance than does the unwritten will. So it names an executor. This is the person that's going to be in charge of paying off debtors and creditors and paying off any taxes, expenses, taking a fee, and then deciding who and when and where distributions are made to the beneficiaries. Typically, a good traditional will waive bond and provide executor compensation, and names beneficiaries, so we know who's going to get the resulting or the remainder of the estate upon the probate estate upon the death of the person that made the will, called a testator. It sets up testamentary trust, so within the will you can have trust built in, and this sets up testamentary trust. And it names guardians for minor disabled children. Let me just say, if anybody on this webinar today has a minor or disabled child and you do not have a written will in place, you need to do this like yesterday. Okay? I mean, if you get anything out of this, if you've got a disabled child or a guardian or a minor child, you've got to get a will, and we've got to name who the guardians are. If you don't do that, those decisions will be made in a 10-minute proceeding in a court, and a lot of times with defective knowledge. I have a brother who has gotten independently wealthy. He's a lawyer. He's suing the state for naming guardians over children, and the guardian is a rapist. So you can see how tragic that is. But name that guardian, name some backups if they're very young, if they're disabled, name backups so we know who are going to be in charge of these people when you pass on.
Right. So even though the will has to go through the government probate process, with the will, you're able to make all of these decisions in advance. Okay, so you're doing all of this work in advance. If you didn't have a will, all those decisions, all that work has to be handled by the court. And there you can see that it's going to be lengthy. It's going to be up for contest. You have to have lots of hearings to decide all these major decisions. You don't have to worry about that if you have a will, because the will decides all of these decisions for you. So you are going to make it a less of a burden on your family if you have a will rather than without the will.
So when we do estate planning for clients, be it a business plan or a will plan or a living trust plan, We are strong advocates of a package, meaning you're going to get more than one document. And that isn't just so we can justify a higher fee. That's because in order to do this right, you almost always have to have more than one document to accomplish what you need to accomplish. So in a typical will package, of course, you have the last will and testament. Now, if you're married, you're going to want a couple a last will and testament for each of you. You don't want to do a joint last will and testament. You're going to have a financial power of attorney, financial durable power of attorney. These have different names. I like financial power of attorney. You're going to have a medical directive, sometimes called a living will, though they really are technically different documents. And you're going to, if you're married, you're going to want to have one document for each spouse. So at ground zero, you're going to want, in a good estate plan, you're going to want 3 documents: last will and testament, financial power of attorney, and a medical directive. If you're married, you're going to want to have 6 documents, 3 for each spouse.
Right. And that's because, you know, as I said before, there are 2 parts to the estate plan. There's the before death, and then there's the after death. And the will only speaks at death. It is only relevant when you die. So you still need to have documents in place for that before death planning. And that's where we have the financial power of attorney, where you get to decide who's going to be managing your money, your income, your assets when you become disabled. And the medical power of attorney is where you're naming the person that you want to make your medical decisions for you when you can no longer communicate to the doctor yourself. The medical directive will also have your end of life decision called the living will.
Here's a diagram of that will package. You see a husband and wife. Typically, at the death of the first spouse, everything goes to the surviving spouse. So that's called an I love you will. And then at the death of the second spouse, it goes down to the beneficiaries, which can be their children, or if they don't have children, they'll name beneficiaries. And then over on the right, this is what Sonia's been referring to, is before death, your disability documents with your powers of attorney, medical directives. These go away when you pass on, and the will triggers in. Let me just give you a little war story, this pandemic war story here. You remember how bad New York was hit and continues to be hit with the pandemic. Well, in the beginning, New York did not have enough respirator to keep all the people with serious COVID illnesses on the respirator machines. So they had to start making decisions of who was going to get respirators. And even worse, they had to decide who was going to be taken off a respirator machine so that people who are more likely to survive would instead get the respirator machine. You can see how awful those decisions are made. And some of these decisions were made without consulting with the loved ones left behind. So if you had, I'm just imagining an elderly person who had an underlying serious problem who was on a respirator machine, the doctors were saying, well, your chance of survival is not very good. I'm taking you off the respirator machine. I know that's going to kill you, but we need that respirator machine for somebody else that we think is going to survive. Well, if the people had a medical directive, the doctor could not make those kind of calls. The medical directive say, doc, you cannot take the person off that respirator machine without having the medical agent approve it. And if you do that, we're going to be suing you, and you're going to be paying a wrongful death claim, and you're going to lose your license to practice medicine. So the medical directive would have given those people that authority. Absent the medical directive, however, the doctor can hypothetically make those kind of calls. I'm taking you off the respirator machine. Sorry, you're dead. We got to give this to somebody who we think we're going to get alive. And you know, your medical director says, no, doc, we're not giving you that power. So that's an example of how a medical directive is an inexpensive document and just hugely important in these kind of situations. Okay, a little bit about probate. So sometimes people think that a will keeps them out of probate. Not so. Both your unwritten will and your written will take you into probate. So let's define probate. So for wills and intestacy cases, a legal process for proving the validity of a will and for distributing your assets to your heirs. Average length of probate is about 18 months, and about 25% of probate cases still going. That's 3.5 years. And I think that's a statistic from the American Association of Retired Persons. I think they did a study. Like I said, about 25% of probate cases are still going 3.5 years later. Sonia can tell some stories about, we have this case that went on for what, 35 years?
Yep.
Hugely lucrative for lawyers.
Yeah.
but not good for the persons that are meant to be the beneficiaries. Average cost probate is 8 to 9%. Requires an inventory and one or more accountings to the Commissioner of Accounts. These recordings are very specific, very time-consuming, frequently rejected. You have to do them over again. And the Commissioner of Accounts sets deadlines, which are not met. You can get fined, and it goes on and on. Again, this is why people a lot of times feel they need to hire a lawyer, and now you're paying lawyer fees on top of executive fees, on top of creditor and predator fees, and that's 8 or 9% is where that's coming from.
Yeah, and Jim, and I was going to mention on the prior screen too, where you had those "I love you" wills. In most cases, couples will keep their assets all jointly titled. Okay, so their bank accounts are jointly titled with one another. Their real property is jointly titled with one another. And so when the first spouse dies, that asset automatically flows to that surviving spouse, and that asset does not go through the probate process or through the first to die will. So in a lot of cases, that first to die will is not used, and all those assets automatically flow to the surviving spouse. And then eventually, when the surviving spouse passes, the surviving spouse's will is used. That's normal in a lot of cases, but not in every case. Now, the reason why probate takes at least 2 years, one thing that you need to know about is, see, the government is not going to allow the executor to make distributions too soon. The executor has to prove to the court that all the taxes have been satisfied, that they filed the decedent's last tax return, and that the government, the IRS and the state of Virginia, they get paid first, you see. And so the executor doesn't even know what the tax status of the decedent is until the end of the year. And so that's why taxes are one reason why there's always a holdup until the second year. So with a relatively simple, non-complex case, it's always going to take about 1.5 years because the government needs to be satisfied that all of the creditors have been paid. And newspaper notices are put in the newspaper, so unknown creditors have a right to come in and make their claims known. And that's what makes it last that long.
This chart is done by a guy by the name of Henry Apps. Henry Apps, who is since deceased. He and I were friends, and he was from the West Coast, but he would come out here. He was a national speaker, and I would have him come out here and speak at seminars, and we went all over the state of Virginia. And Henry Apps has written a best-selling book called The Living Trust. I think you could probably find it in your library. But this is one of the pages from that book. I'm not intending for you to be able to read this. This is probate, and one of the reasons I bring this chart up is because some of you have probably been through probate with maybe a spouse or a parent or a friend or something like that, and maybe it went lickety-split. And in fact, a fair number of probates do go lickety-split. If you go right down, you go right down the pike there, and there's no going to the left or to the right. It can be done fairly quickly. Like I mentioned earlier, about 25% or 1 out of 4 probate cases go to the left or go to the right, and then you're stuck there for years and years. And there's people just nibbling off this situation. So I guess the idea here is, do not think that probate is typically easy, or at least it's not easy in about 1 out of 4 probate cases.
Right.
So,
and Virginia has a small estate process too. So if the assets are less than $50,000, then you're likely going to have a much shorter process. And a lot of people die with some assets go through probate, the will, and some assets are jointly titled with others or have beneficiaries named on them. So it may be that the largest part of the estate flows automatically to named beneficiaries and doesn't go through the will. And it really depends. You really never know what the process is going to be until you get to the courthouse, and then you really have to wait and see who's going to file contests against the will, what claimants there may be, to determine what the process is going to be. But sometimes it could be a quick, simpler process. Jim?
In the last few years, there's been an interesting development with helicopters arriving at scenes of accidents. And what's happening now, as I understand from a couple of clients, is that if you are in, say, an auto accident and you are say you're killed even, and the helicopter comes in to attempt to rescue you and takes you to the hospital, that's not a free ride anymore. The company is going to bill your estate, and I forget the fee, but I want to say $30,000 for a helicopter pickup at the scene of an accident. And so even in a small estate where you have under 50,000, you're going to have that claim against the estate that's going to need to be resolved before you're going to be able to get out of probate. So having hopefully indicated that we're not fond believers in probate, there are people, professionals and people who attempt to avoid the probate, and this is their exclusive estate planning objective, is to avoid probate. And although avoiding probate is extremely important, there are so many other things to consider. And the poor man's will, the poor man's plan is an attempt, it's a very common, this is why we spend some time on this, of planning an estate, but you're going to see, we'll get a couple slides on this, that it is indeed a poor way to plan. So here's an example of a poor man's estate plan. What you do is you take your various assets and you do what's called probate avoidance techniques. So with joint ownership of real estate on the top circle there, or the circle to the left, the blue circle, joint ownership, it's TIC, tenants in common, TBE, tenants by the right of tenants by entirety, JTWRS, joint tenants right of survivorship. All of those avoid probate. So it goes down, the real estate then goes down to the surviving tenant, and then without having to go through probate. Transfer on death for investment accounts, also avoid probate. Pay on death, POD for bank accounts, avoids probate. Beneficiary designations, say with life insurance and retirements, all avoid probate. Now, the problem, there are all sorts of problems here that you can probably begin to see, one of which is this. Look how complicated this is. You have to first of all identify each and every asset in your estate, and if you miss an asset, let's say you miss your household items, those household items may still have to go through probate. The commissioner may still need to force an inventory of those personal property items, and on and on. Or you might have you might forget, you might have 3 life insurance policies and you only name 2. And you got a third one that's a rogue and doesn't follow the plan. This goes on and on. We could probably spend an entire webinar just on all the pitfalls to what's called this poor man's estate plan.
Yeah, the biggest problem here is, what I see the biggest problem is if you put your son on your bank account, you make him a joint owner of the bank account, you are suddenly exposing that bank account to your son's problems. If your son goes through a nasty divorce or has bankruptcy or creditors after him, those creditors are going to be looking at that joint bank account because you've given him a portion of that account. Or you might put your daughter on your house. And you're thinking that, well, if I die, that asset will go automatically to my child, and my child won't have to go through a probate process. And that is true. If you should die before your child being the surviving owner on the asset will get that asset. But the huge problem is what if your child's going through a bad divorce or has creditors? Now suddenly, your asset could be tied up in that mess, as well as you're only allowed by the IRS to give up to $15,000 per year to any person. So you might be violating the gift tax law. So that's a huge problem that we see. Another thing is you can't control the contingencies. So what if your daughter should die before you? You're back at square one. Or if you name your daughter as the beneficiary of your bank account, thinking, okay, if I die, she gets the bank account. But what if she has creditors after her? You're really giving that bank account to her creditors. So there's lots of problems with having a plan like this, as well as this type of plan doesn't cover the before death planning. This plan you're not naming anybody to be able to manage your assets for you when you become disabled, incapacitated. So this is really just that after-death planning, and it's not a very good plan. And we've seen families ripped apart by this type of planning, because parents are trying to equalize everything out between the kids, and inevitably one child receives less than one child. So we say it's a poor way to plan, and there is a much better way. And we're going to be talking about the living trust here in a moment, Jim.
Voila, there we have it. Okay, so let's regroup. Where have we been? So we talked about the unwritten plan. That's where you don't have anything in writing, such as a will. You have the written plan where you have a basic will in place. And then the third plan is the poor man's estate plan, which is trying to avoid probate altogether. And by the way, the poor man's estate plan not only avoids probate, but avoids bypasses the will. So if your will says one thing and the poor man's estate says another thing, the poor man's estate plan trumps the will. So we got a bunch of problems there. All of these problems, or if not all of them, most of them, are solved by what's called a living trust plan. And that's what we're going to spend most of the rest of the presentation here on this. Now, some people will say, oh, living trust, well, that's good for, for the Rockefellers and the Kennedys and the Trumps, but not, I don't have enough assets to do this. Not so. These four general advantages, which we're about to list, are applicable to all people, regardless of how small your estate might be. So, first of all, we avoid conservatorship. So if you are disabled, mentally disabled, or you're in a nursing home, the living trust continues to manage your affairs without us having to go to court, get a conservator appointed to you, and do conservator reports annually. Avoids probate proceedings. So at the death of the living trust maker, or the trust maker of the living trust, all that trust maker's proceeding assets are avoid probate. Goes directly to the beneficiaries. Improves beneficiary plan. Because we're not subject to the court system, we can be a lot more creative with beneficiary plan. We have one slide that shows you all the different options we have available to us, and all of those options work much better in the living trust plan. And then it simplifies and increases control. Although the living trust itself is a bigger document, in reality, in practice, it greatly simplifies, increases control over your affairs.
Yeah, and that's exactly right, Jim, because the living trust is the only document that we've talked about today that covers both sides of that estate planning. The before death, the after death. Your living trust will name someone to manage all these assets before you die. That's where you avoid that conservatorship proceedings. I had a couple once. It was an elderly couple in Spotsylvania, and the woman had got Alzheimer's, and they had no documents in place. They didn't even have a financial power of attorney, which would have avoided the guardianship of her. Well, she was placed into a nursing home, and the husband was shut out. He couldn't make any decisions about her, even though he was, the husband, and she was his wife. And so it was really, really sad. And he had to go and hire a lawyer, which, by the way, charged him $7,000, so that he and his daughter could be a guardian and conservator over his wife, her mother. And then it was just after that, for the next 2 years prior to her death, it was just miserable, because they had to file all these reports with the courthouse and keep receipts. So they had to keep track of all the money, you see, that they spent for their mother, her share of the assets. And so I can tell you right now, I wouldn't want any of my family to have to go through that. And the living trust will avoid that, as well as the living trust serves as a substitute will. So there's no going through probate when you pass away. Jim.
Okay. All right, so we mentioned package before, and we've talked about will, so we're going to have a package here. And we have the living trust agreement. I call it an agreement. The living trust is technically a contract. That's important to know, because it's governed by contract law, not probate law. And under the United States Constitution, we have, although it's greatly been diminished, but we still have the right to contract freely without the government interfering. So this is basically a contract that overrides the probate code and puts you completely in control. You get to write your own agreement the way you want it. Yes. Power of attorney, the financial power of attorney that we talked about before, the medical directive, and we still have a will. It's called a pour of a will, and the purpose of the pour of a will is to capture any asset that's not titled to the trust that goes through probate. Now, we want to avoid that, but we have to have that backup plan just in case it happens. Also, the poor of a will appoint the guardians for minor or disabled children. And then funding documents. In a crowd like this, I suspect several of you have living trust documents, and I would suspect at least a few of you have a improperly funded or unfunded living trust, meaning you haven't moved assets into the living trust. And if you haven't moved your assets or titled your assets to the living trust, you basically have more or less wasted your time and money. So you want to have that trust funded with your real estate, with bank accounts, investment accounts, life insurance, retirement accounts, business assets, et cetera, and those are generically referred to here as funding documents.
Right, that's right, Jim. And so, you want to get all your assets into the living trust, and we're going to see here in a minute that the living trust is really just your mirror image of you. It's just your alter ego holding your personal estate. But there are some assets that you have that, because of the unique, special nature of the asset, we can't put that asset into the living trust before you die. And that's why you have the financial power of attorney, which will cover those non-trust assets. You see, we can't make your living trust the owner of your Anthem Blue Cross insurance card. We can't make the living trust the owner of your Medicare card, right? So when you become disabled, the financial power of attorney is going to be there to manage those types of assets for you, file your tax return, pay all of your bills, and those types of things. So that's why the financial power of attorney is still necessary, even though you have a living trust, which holds the bulk of your assets. Jim?
Okay. Again, I'm not winning any Pulitzer Prizes for photography here, but this is what a living trust binder looks like. It comes in a red binder, and sitting on the table is a gray envelope. So we are one of the few law firms that provide our clients with 2 sets of originals, because we have found that people misplace their originals. So less likely we're going to lose 2 originals. So the red binder is designed to be kept in your home, and the red binder is designed to be kept in a fire-safe place, either at home or in a bank or some other location. So in case the house burns down, we'll have a backup original. Again, the typical law we need to assume will be in play is that if we can't find an original document, even if we have a bunch of copies, the copies don't count. If the original is lost, the document has been revoked.
Yeah, and Jim, I always tell my clients for the red binder, they want to keep a list of all of the assets of their trust inside the red binder, as well as some verification that they've placed that asset into the trust. And the red binder is really nice because it's a talking tool. You use that when you meet with your families. I suggest every year meet with your families, and you go through the binder and explain to your family how your estate plan works. So the red binder is really nice for that as well.
So here's a diagram of a basic living trust. You have the living trust agreement. The trust involves 3 contractual parties: the grantor, we call it the trust maker, which is you, the beneficiary, which is you, and the trustee, which is you. So we have 3 parties. They're all you. This is why Sonia mentioned it being your alter ego. It will tell you that common law, you couldn't do this. You couldn't be your party to your own self in a contract, but every state in the country has overridden this with the living trust as an exception to that common law rule. And you basically enter into a contract with yourself as trustee. Created by yourself during your lifetime. It's funded with your assets, and it controls your assets when disabled and upon death. So, all right, I want to just say quickly something about asset preservation trust. So your asset preservation trust is an attempt for married couples to protect the estate from the surviving spouse's problem. So what we do in an asset preservation trust, depending upon the wealth of the estate, we'll set up a family and or marital trust. And these trusts are designed to protect the estate from the surviving spouse's problems. Let me give you an example. A husband dies, his wife is in a nursing home. We'll say it's a $2 million estate. We've put $1 million of the husband's estate in either the family or the marital trust, and the other $1 million that is owned by the surviving widow can be used and taken by the nursing home. But the $1 million that is owned by the decedent husband is a lot less likely. I wouldn't say impossible, but a lot less likely to be taken by the nursing home. Same thing would apply if the surviving spouse is in a lawsuit, or the surviving spouse is going through bankruptcy, or the surviving spouse has married a gold digger. We can protect the decedent husband or the decedent spouse's estate from the surviving spouse's problem. So it's a wonderful way. I strongly advocate at least a marital trust for my married couple's estate, because it's not a very expensive add-on. I think it's $350 to throw in an additional marital trust, and it could save you a huge amount of money down the road.
Yeah, one thing to keep in mind is that, you know, when we said the living trust is a mirror image of you, it's your alter ego. It holds your personal estate during your lifetime. So there's no creditor protections. We can't protect your living trust assets from your creditors during your lifetime. But when you die, then those assets are protected from your beneficiaries' creditors. And in this illustration, for a married couple, we're using a joint living trust here in this illustration. So when the first spouse dies, then we're able to save maybe up to half of the estate or more from the creditors of the surviving spouse. So after there's been a death, then we're able to protect a portion of the assets or all of the assets, if it's a child, from that beneficiary's creditors. So that's where we can get this asset protection, Jim.
Okay. Trust to provide for credit protection, spouse, children, and other beneficiaries. So these are, when you come to us, which I hope you will, one of the things that we pride ourselves in is directing you to a recommended, these are called sub-trusts. The recommendation for marital sub-trust, if you are a married couple: inheritance protection trust, common trust, general needs trust, spendthrift trust, lifetime trust, special needs beneficiary trust. These are all types of trusts that we have, and generally in our living trust, which we call the master trust, we'll have as many as 2 or 3 sub-trust types depending upon the situation. For example, if you have a child that's on drugs or alcohol and can't seem to break the habit, we would probably put their asset into a lifetime trust. If you have multiple minor beneficiaries, we might start out with a common trust. If we have a well-adjusted, happily married, financially sound child, and there are a few of those out there, we might do what's called a convenience trust, which means they can take their inheritance out whenever they want to. So those are things that we'll discuss at our first meeting when you come in to see us. I happen to be the father of a disabled child, Jimmy. I'm on the right there, and he is on the left. Jimmy is disabled. So Jimmy will never receive an inheritance. He's been declared by the courts to be incompetent, and he will never receive inheritance. But he will receive inheritance in a special needs trust, where a trustee will be able to, probably his sister, will be able to allocate assets to him for his entire lifetime, one of which is to go on cruises if he wants. This particular picture was taken, Amber Anderson had us over for a weekend, and we stayed at her backyard, and that's her boat in the backyard. So don't think that your VCA agents are not getting paid well. Of course, I jest. Okay, Sonia, did I pass over you here? You okay?
Yes, I'm fine, Jim.
Okay. All right. Just want to throw in here, I mentioned before, we do a dynasty trust. There are ways, generally in a group this size, there'll be 1 or 2 people who have an asset, like a real property in particular, that they want to really keep in the family. Maybe you've already had it in the family for several generations, and you want to keep it going for several generations. Typically, you're not allowed to do that. It violates what's called the law against perpetuities, but there's been a big, huge exception carved out by many states, including the state of Virginia, that allows dynasty trust to be created that will allow real property to be passed on to multiple generations. And as I mentioned, I have a client with a vineyard in the Northern Neck, and that's exactly what they're doing. They have 2 children, they have several grandchildren, and we're creating a dynasty trust that will pass the vineyard on and on. And I believe if we run out of heirs, then it defaults to Virginia Tech. So Virginia Tech will be the proud owner of a vineyard in Northern Neck, unless, of course, they turn it down. But that's the dynasty trust. I bring that up because I think I find that one or two of you may be interested in passing real estate or a business for that matter down to multiple generations. Okay, so finally, we're kind of in a wind-up mode here. How do we combine your business planning, which was the first two parts of this, with estate planning? And this is, so we pass, first of all, the question is, how do we pass your business? Businesses can be passed by lifetime gifts, can by a contractual agreements such as buy-sell agreements, and by testamentary gifts, either by way of a will or a living trust. I strongly advise against passing a business under a will, because that's going to put that business under the control of the Commissioner of Accounts, who runs probate in Virginia, and you're going to find yourself having to possibly answer for everything that you do in that business, and it could be really traumatic. I had a case, Sonia and I had a case some years ago where parents died, and I think in a common disaster, I want to think, and they didn't have anything in place, so they died intestate. And the logical executor was one of their sons, but the problem with the son is he had a few years ago filed bankruptcy. And so the probate court said, no, we're going to name you as executor, but you've got to find a lawyer that's going to monitor everything you do. And the guy came to me, and for, I think 5 years, we monitored everything he did. Everything had to be checked off by us. We had to countersign all the checks. I think by the time we'd done, I want to say 300 to 400 hours of work. And we gave him a deal, but even the deal was $45,000. So there's an example of where a business got caught in the probate process, and needless to say, the son was really unhappy. And I said, don't take your frustrations out on me. I wasn't the one that puts you into this situation.
Yeah,
so,
I remember that case well, because at the end of the 5 years, there were 5 black binders, and these binders were like 3 or 4 inches thick, and each of those was for the annual accounting, because the whole farm had to be dismantled, and the inventory was, I don't know how many, 20 pages long. And I think it had like 150 items on the inventory. It had all the farm animals, all the machinery, all the tools. And that's what the commissioner required. So that took a lot of time to prepare that inventory. We had to have everything appraised by an appraising company.
I think Sonia, wasn't it everything over $500 had to be inventoried?
Yeah, every item that has a value of more than $500 has to be on its own single line. And I remember that case because we had like 144 items on the inventory. And it was a huge project. And the son and his brothers were not happy because of all the legal fees that had to be paid, because he was having to be supervised by Jim. Because he couldn't handle it on his own, because he couldn't get a surety bond because he had filed bankruptcy. All of that could have been avoided completely if his father would have just put everything into a trust, assigned the business to the trust. Then his son, as trustee, could have managed everything after his father died without any court involvement. So we see this all the time.
So if you do have a limited liability company, you establish one, and you do want to pass it on to your children, there are a number of ways you can gift your LLC to children, to spouses, to other beneficiaries. Lifetime gifting, very easy through LLC. Like I say, you just conduct a meeting, have everything in writing. Transfer by contract, such as buy-sell agreement. Gifting by intestacy, that's where you don't have a will at all. Obviously, we advise against that. Gifting by will, we also advise against that. And then gifting by living trust. So if you have an LLC, we're going to recommend a living trust. Now, we've had a number of clients say, thanks, but no thanks. We'll do the LLC and we'll do a basic will. That's fine. Our job is to give you our best recommendation, and you're the boss. If you want to just do a basic LLC and a will, we'll run with it. And I've had a client recently say, we're going to have an LLC, we're not going to do anything. So that means when they die, it's going to go through intestacy, but that's what they wanted to do. This, I have alluded to this chart a couple times. The blue up there is real estate owned by the business. Let me give you an example. Suppose this is a doctor, and the doctor owns his own building. So we put the doctor's building in the blue family limited liability company, and then we put the doctor's medical practice, his professional corporation, into an operations LLC. So if he gets sued for malpractice, they can come after and get his operating table and his medicine cabinet, but they can't get the building, which is what the law people suing really wants. And there's a lease agreement there. And you can do this. I mean, I have the same arrangement with myself in my business. I have in a lot of my farming clients have this kind of business arrangement. And then you can see how it goes down to your living trust and then down through the beneficiary. So, you know, the probate clerk, the probate judge, the commissioner of accounts, the public is not going to know anything about what's going on here. This is going to all be settled in the private confines in my office, and nobody's going to know anything about this, and that's the way you want it. Okay, a little bit about the process that this office uses. Again, how to contact my office. We mentioned this earlier. You can get today's PowerPoint slides. I think Amber will pass that out when you fill out the registration, introductory booklet, evaluation sign-up form, and if you do that, there's a 5% discount certificate on our fees, and that's not a make-believe, that's true 5%. So again, this is the evaluation form that we're gonna, if you call in, you'll get that. Please evaluate us. We'd like to know how we're doing. And we know that we don't always make everybody happy, but if you wish we'd done something different, then please let us know. Here's the discount certificate that I just mentioned. Estate planning process. So how do we go from now to having the document signed? We use, at least for our estate planning documents, we use a 4-meeting approach. Initial meeting or introductory meeting. We review your personal family dynamics, assets, set goals, objectives, flat fee, and set the next meeting. Very profitable meeting. Even though we're not charging for this, you're getting a lot out of this. So people do walk away and say thanks, but no thanks, and that's your prerogative. If you do go forward, we then have a planning meeting or a design meeting. That's where we review your documents and we go through your assets and prepare a client questionnaire so we can then begin drafting the documents. Meeting number 3, a signing meeting where we execute the documents. At the planning meeting, we collect half. We typically charge a flat fee, which substantially reduces our overall, or substantially reduces our fee if we were charging hourly rate. And we charge 1/2 at the planning meeting and 1/2 at the signing meeting. Just to let you know, our documents go through anywhere from 4 to 5 reviews before they get back to you. And then for those of you doing living trust, we have a note for no additional charge, usually 3 months after the signing meeting, we'll have one of the paralegals call you to go over your assets to make sure they've been funded to the trust. This is assuming you do a living trust. Because if you're doing a will, your next step is probate. If you do a living trust, your next step is to do the funding, and that's we're hoping that's done within 3 months from the date of the signing meeting. Some years ago, Northwestern University did a study on estate planning, and it's really kind of an eye-opener. They said for every 5 to 6 hours of estate and business planning, you save $150,000 to $200,000 in business estate costs. And I tell you, you've heard some more stories tonight today that will give you an idea of why that can be true. We're reducing time costs and delays, emotional costs, family conflicts, and leaving a legacy of love. For those of you who have documents in place, of course, you are recommended to go back to your original lawyer. But if you want us to take a look at your documents, we'd be happy to do that. We recommend your documents be looked at every 3 years. My experience has been that after 3 years, people begin to forget who they have named as their executors and beneficiaries. And so this 3 years is a good time to look at those documents, peel open the crusty document that's been sitting in the attic and see what you did 3 years or sometimes 10 or 15 years ago. Also, we'll recommend helping you do annual business meetings if you want to do that. And certificates of ownership. This is the business planning review, assignments of businesses, bylaws, and operating agreements. So if you come to us with an existing business, these are the kind of things that we'll be helping you with. And I will tell you, there's rarely a business that people come to me with that I don't see some critical needs and updates that need to be done. And then this is the estate planning review. I jumped a little ahead before, but we'll look at your will, your power of attorney, your medical directive, testamentary trust, fiduciary beneficiaries. We'll look at all of that. And again, I can't even remember, maybe once or twice in 27 years has anybody come to me and I've given them a clean bill of health. There's always, hey, you've got, here's a critical need, or you got to update this, or there's a new law here, or your fiduciary has died, or your beneficiary has become estranged or whatever, and we got to update the plan. For those of you who are veterans, active duty military, federal government employees, we salute you, and we do have special planning. I'm a former JAG myself, so I did a lot of estate planning in the military, and I've also given speeches to federal government employees. So we just finished a case. I think this was Sonia, one of Sonia's cases, I think, or maybe it was mine. But the guy was military, and he had, as a lot of military people, they sometimes have properties in multiple states. So we did what's called a multi-jurisdictional documents for him. And he was in Virginia at the time. He just got transferred to Maryland, to a base in Maryland. And in the meantime, he also had a child, and he called up and said, hey, do I have to update it? I'd prefer not to. Do I have to update it? And I said, no, you don't have to update it. It would be a good idea. But your multi-jurisdictional case documents will follow you wherever you go. And the fact that you've had a child, we like to see the child added in, but we already built in afterborn or adopted children, so you're good to go. And he was a very happy camper. When you do call my office, you're going to reach Linda, and this is her sitting in her office downstairs. And she's a very pleasant person. She's got a nice Southern accent, and she will take care of whatever whether or not you're just asking for some of the documents that we indicated that we can give out to you, or hopefully maybe you're calling to set up an initial meeting for either Sonia or I to see you. And I think Jennifer and Amber have indicated that we're going to be doing more of these in the future, and I hope we do. I really, this is stuff that really, I tell you what you heard this morning, at least in my experience, people are not hearing this and they're not getting this done. And so hopefully we do more of these. And I want to thank David Wise again for co-sponsoring this. David Wise also was our lead marketing person. So appreciate that, David. And I am glad that Sonia, we weren't sure if we were going to get Sonia in today. She's a highly sought after person. And so we were able to get her in at the last minute. So Sonia, thanks for joining us.
Pleasure.
And your VC agents are second to none. Thanks to you, Jennifer and Amber.
Jim?
Yeah.
I have a question in the chat box. If you, it's actually pretty lengthy. So can you click on the chat box from your screen and read it?
Just send
Let's go ahead and read it for those.
Okay. All right. So it says, my father passed in 1999, and he had 11 acres, his portion of the family farm. My mother, who I've had to place in an Alzheimer's unit after a kitchen fire and a more than an hour drive from the house and repeated incidents risking her safety, My mom never placed the acreage into her name. My father allowed me to grow timber on this parcel where I have land adjacent to. Should I transfer the land to myself? My mom has a will and a power of attorney and a medical directive with me as her sole heir. I plan to use the value of the harvested timber to pay for her care. She will likely spend down all of her assets in about 6 months.
Oh, wow. Well, my first thought is, like yesterday, you want to get that 11-acre of property out of your mom's name. You absolutely want to get that out of her name. And unfortunately, under current Medicaid laws, that transfer has to occur 5 years before you apply for Medicaid. And the idea of applying for Medicaid is Medicaid would pay for the nursing home expenses rather than having to use the timber income or the sale of the land. But if there's any chance at all that your mother's going to survive more than 5 years, I would get that property out of her name like yesterday. And as her power of attorney, you should have authority to transfer that property from her name to, well, we don't even know if it's in her name. I guess, yeah, there's probably some things I have to look at here. Be interesting to see if I think you said your dad died. It'd be interesting to see if he had a will and who he left the 11 acres to. I'm assuming it went to your mom. That would be your typical scenario. This is a good example of how, really, really pretty basic, simple plan. We could have saved that, and we could have for sure saved that total 11 acres. We could have saved all the timber income. We could have saved everything else mom might own, be it a bank account or a car or a life insurance policy. Pretty basic planning. And it grieves me to see this sort of situation. I mean, you're really in a rock and a hard place. But I tell you, you give my secretary a call, we're going to get you in, and we're going to get that deed transferred out of your name. Well, maybe we'll beat the 5-year rule, maybe we're not, but a deed is not costing you that much to transfer that, and it's going to save you. By the way, the first living trust I ever did was my mother's living trust. Actually, my brother Mark was a lawyer, did it. I worked with him on it, and we transferred. My mother was in a similar situation. My dad had died. Mom was in a nursing home. We transferred everything from her name to our name, the kids' names. There was 5 of us in a living trust, and we paid. We had in that day was 3 years, so we paid for 3 years of her nursing home, and then when she passed on, we saved the family home as well as another $250,000 that would have been completely taken by the nursing home because she was in a nursing home. Geez, I think it was 6 years maybe. And, and as David Weiss, who's on this, knows this really well. But, your nursing home are just outrageous, the cost now these days. I mean, $100,000 a year it's really probably not unusual. So I don't know if I answered the question, but I would urge you, if I were you, I'd get into a lawyer's office. Call me if you want to. We'll get you in. And if we have to do a telemeeting, we'll do that, and then get that deed transferred to your name. I'm assuming there's no other siblings involved, because there's other siblings involved. That's going to complicate things further. All right, so long answer to a long question. Sonia, you want to add anything to that?
No, everything that you said, I would have said. And again, I mean, transferring the property to him would be the thing to do right now. Maybe not to him, but maybe to a trust, so that we protect it from his creditors as well. But we'd also want to know if there's any other siblings involved. I think he said he was the sole son, the sole child.
Okay.
But no, I agree with what you said.
The other thing we might recommend is if you're going to do ongoing timbering, 11 acres is probably not that big a timber produce, but if you're going to do ongoing timbering, I would recommend an LLC for just the timber operations. My timbering is a dangerous business. We had a family friend killed by a tree falling on him during a timber operation, and this guy was very experienced. The tree went the wrong way, and he no longer is alive. So, I would put your timber business into an LLC. Because just to give you an example, if a timber does fall and you're blamed for it, a wrongful death claim can be, I don't know, $3 to $5 million, and you sure don't want to pay that out of your pocket. So you want to have them limit the liability to the timber business itself.
Right, and also putting it into the son's name would escape probate when his mom eventually passes away, and then putting it in son's name, if the government wants to use the value of that property to pay for her medical costs, I mean, the son could make up those costs with other means rather than having that property having to be, well, I guess the big benefit was it gives you more control over it during her life and then after her death. Jim.
Okay. Amber, any other chat questions?
We don't have questions, but we do have two comments. So one is from Dr. Alex White. It says, make sure your heirs, executors, and attorneys know about your estate planning documents and the location of the documents, and make sure they have access to them, etc. Don't keep it secret from them.
Yeah. Yeah.
And David Wise said that make sure your extension agent, oh God, not extension agent, oh Lord, your insurance agent is aware of any changes that you plan to do in regards to your business entity. For instance, setting up an LLC. If you retitle a vehicle to the new LLC and you don't have an auto policy already in force for the LLC, you're basically deleting your insurance coverage until you apply for the new auto insurance policy for that LLC. I would recommend that you set up your new auto policy for the LLC before you retitle that vehicle to the LLC.
Yeah. Dave, thank you so much for that comment. And sometimes David joins us in these presentations. We miss not having him today because he's got some incredibly good ideas about how to work with insurance and LLCs that are beyond my pay grade. Yeah, and was it a professor? Is there a professor on that made the comment, Amber?
Yes, Dr. Alex White.
Okay, I appreciate that. And Dr. White, it reminds me of a story that happened a few years ago. This was a Farmville client that died, and I met with the daughter. Actually, I met with the family. I met with the mother. That's what happened. And then I think the mother died, and we could not find their will. And they did not tell the daughter where the will was. She thought I had it. Well, I didn't have it. And in fact, I didn't even do the will. It was done by another lawyer. And we searched high and low forever for that will, and we could not find it. And they went to court, and they tried to say to the judge, because we found a copy. And the judge said, I'm not accepting that copy. I'm going to treat your dad, I think it was the dad we were working at that point, as dying intestate. And that result of that intestate decision by the judge was awful. I mean, there were some awful results that came about. And again, so yeah, if you've got estate planning documents, let your kids know where they are. And I even offer meetings if you want to have a family meeting where we can get together and tell. When I just had sort of one yesterday, where the parents say, hey, this is where I'm going to keep the red binder, this is where I'm going to keep the gray envelope, or in the case of a business, this is where I'm going to give you the black binder and where I'm going to keep the red binder, the gray envelope.
Yeah, and I always tell my clients that I encourage my clients to have an annual meeting with their children and their trustees, and go through the binder with their children and explain to their children what the process is and who's going to be in charge when mom becomes sick, and who's going to be in charge when mom and dad eventually pass away, and explain to the kids, especially if you're using a living trust, that the children will be able to handle all of this in the privacy of their own home without having to go through the probate process. But and I tell them, you need to tell the children where you're keeping your documents at. We give you 2 sets of originals, and we tell you to put them in a safe place. So the children need to know if there's a safety deposit box that's holding your documents. The children need to know that. They need to know where the key is to the bank safety deposit box. They also need to, if you're using a vault for your home, they need to know that, and they need to know the combination. A lot of times I tell my clients, give your child, the one that's the trustee, a key, a copy of the key to your home, because they need to get into the home after you die. And I had a case once where the child was trying to get into her home of her deceased mother, and the cop showed up. The neighbor called the police on her. And of course, she had her red binder, and she was trying to tell the police officer, "Well, I'm the daughter, and she's dead." So the police were fine with it. But it's a good idea to give your child a key to your house, or let them know where the key is going to be hidden around your house. But very, very good point.
Good question. All right, come on, the rest of you. You've got two experts on scene here. Shoot away. All right, well, let me talk a little bit while maybe someone's writing in some chat stuff. So again, thank you for coming. I cannot, I said this 3 times now, but the information you got here today is really valuable, and please walk away with it and utilize it. We would love to have you come in, but whoever you go to, go to somebody to help you out, and we'll be more than happy to do this. We are fully running, notwithstanding the pandemic. We have Zoom meetings, we have go-to meetings, we have phone consults, we send stuff, documents by overnight mail, and by email, and scanning stuff, documents in. And so, in fact, now there's been a trend in some of the local governments to do a lot of stuff electronically. So for example, Fairfax County no longer accepts paper deeds. You now have to file everything electronically. We had one rejected paper deed. So, okay. Amber, Jennifer, you want to say any closing comments?
Wait, we have one more question.
Okay.
That box, and it says, when or how do we? Oh, wait, that was to me. Never mind.
When or how do we get a hold of our VCE agent?
Yeah.
They're all on vacation. No, that's not true.
Yeah.
No.
Well, so if there are no more chat questions, we can go ahead and conclude. James Silo's information is there on the screen for further information, and of course you can always contact your VCE agent as well. Jim, did you have something else?
Well, I was going to say, I guess we're getting short of time on it. We got to close this out pretty quick. But I mean, do you want me to hang out here for a while, or are we too short of time here? I see where this is taking a little bit longer than we had.
Yeah, I think they have your email and phone number. I think if they have questions, maybe we can go that route.
Okay.
But please, everyone, do remember to fill out the evaluation form to help us bring you more programs that you need. We are here for you with anything. So we do appreciate that. And I'll let Amber close as well, since she is our tech support here. And I just want to thank y'all again and have a great day. Amber?
Oh, what? Yes. I put the evaluation in the chat a couple times, but if for some reason you do not get the link, you can email me, and my email is aamber@vt.edu, and I can put that in the chat also.
Yeah, by the way, there are some people that I think a couple people have phoned in. Hopefully they're going to be able to get contact information as well.
Yes, I already had one person email me and get that
Okay, great.
that information, but I just put my email in the chat box, and again, that's aamber@vt.edu. And you can email me, and I'll send you the evaluation link, and once you fill that out, it might take a day or so for me to get back to you, because as soon as this is over, the recording is going to take a little bit to download, and it usually takes a little bit of time. So anyhow, but we should have that out to you within the next week.
Great. Well, thank you all. Thank you, James. And thank you, Dave. And yep. Thank you.
Stay well and stay off the streets. Bye-bye.